what you need is the policy documents. Now, those who are here this morning heard a little bit about that when we talked about disclosure. And one of the things you want are the policy documents, and that's mainly what I'm going to talk about today. You're entitled to disclosure of those documents. The competency, the honesty, and the open-mindedness of investigators can have a profound influence on your case. Investigative policy provides a way of assessing this without you getting bogged down in all the detail, all the paperwork you've got to go through. But we have to start with certain assumptions about how your case should be investigated. And there's a whole prescribed list of them. The purpose of policing is the preservation of life, the protection of property, prevention and detection of crime, and the prosecution of offenders, in that order. A valid investigation is a managed search for truth, in which equal attention is paid to locating evidence capable of implicating and eliminating suspected offenders, and disclosing information that may assist the defence or undermine the prosecution. The fairness of an investigation is dependent upon the absence of prejudice, bias, or other assumptions. For example, a fingerprint is unequivocal evidence of identification. It isn't. It's an opinion. The efficient, effective, economic, and ethical management of any process is dependent upon maintaining a concise, accurate, comprehensive, contemporaneous record of who did what, why, when, and where. Now, all that is the investigative policy, and that's what I'm suggesting that you look at. Well, what is the investigative policy? How does that help you? Well, the investigative policy is to an investigator what a statement of accounts is to an investor. You wouldn't buy a business if you hadn't looked at the accounts first. So why would you ask victims, suspects, or the courts to accept the outcome of an investigation without seeing the accounts of how that investigation was managed? When business people use double-entry bookkeeping to match income against expenditure, detectives use investigative policy to justify decisions with information. In much the same way, if there was an absence of a watermark on a banknote, you might suggest that it's a forgery. The absence of a valid, properly documented investigative policy may point to a forged investigation. How can you, without accurate documentation, how can that investigator claim to have identified, let alone followed, all the lines of inquiry? When you look at these documents, when you get them, and they're mostly contained in the Home's computer record, the Home Office large and major inquiry system, when you get these documents, how do you assess them? What you've got to look at and keep in mind is the investigative styles, the approach that the investigator took. And there's clues to what you should be looking for. And I've basically put them into 5 styles. The incompetent investigation, the political, the fearful, the partisan, and the corrupt. And of course, it may contain elements of all of those. The incompetent investigation, it's conducted by people who don't know what they're doing, but they think that they do. There is some evidence that the incompetent are those most likely to be unaware of their own failings. They have inflated opinions of their own ability, poor judgment. They have a desire to conform, and they're more likely to accept decisions on authority and the general consensus of what's happening in the investigation than actually looking at the evidence. Investigative policy born of incompetence may lack adequate documentation, and when it does exist, it's rambling, and it's confused. And the result, you may have a long list of actions where there's no any sort of justification for those actions to be taken. By an action, I mean a line of inquiry that's actioned. That's the word. In other words, if this looks like a shambles, then that's probably exactly what it is. Then there's the political approach. That's a sort of learned incompetence. Sycophants. They're trying to curry favour. But unlike the truly incompetent, they usually know exactly what they're doing. They have a fear of being held to account, and that may result in a poor record keeping, a tendency to blame others. Favoured strategies are a reluctance to sign documents. They avoid difficult issues. They demand that victims and witnesses prove the allegations. They interview you and say, oh, well, you have no proof of that, have you? Well, what are they there for? That's what they're there for, to investigate it. That's the kind of tricks that they use. They won't follow any problematic lines of inquiry. They'll keep clear of those. They won't keep minutes. Their logic is sometimes utterly bizarre in order to justify it. And they will appoint quite junior people in the investigation so they can lean on them. These are the things you have to look for the paperwork. And then there's the fearful investigator. I don't know if it does surprise you, but sometimes police officers and detectives are afraid of the person that they're investigating, that they'll do the wrong thing. They might be afraid of having their work reviewed or be criticised, or for example, putting their case before the High Court. The result may be poor record keeping or a long list of excuses. There is an old saying in the police, if you don't do anything, you'll never get into trouble. Then there's the partisan investigators. They have strong prejudices or beliefs. For example, children never lie. And these prejudices dominate their thinking. They're even willing to make naive statements actually within the records themselves. For example, the purpose of this investigation is to prove Jim Smith is guilty of robbery. Sometimes you'll see this. There may be a series of negative statements. We are not looking for any persons in relation to this, any other persons in relation to this offence. Then there's the corrupt investigation. Investigators prostitute themselves for money or other advantage. They can be highly ambitious political operators to highly competent but thoroughly disillusioned detectives. Whatever the motivation, the methodology remains the same. They make the facts fit the desired outcome. That may involve planting and losing evidence, inventing and editing information, destroying documents, suborning witnesses. Telltale signs. The sudden appearance of critical evidence, the loss or lack of supporting documentation, failure to use standard systems and procedures, and lack of management supervision. They can also include the production of perfect documentation. For example, typed policy records. The policy records are a day-to-day record kept by the senior investigating officers. They're usually handwritten. They're obviously going to contain mistakes, spelling mistakes, grammatically incorrect. If they're perfect, I'd look at them very closely. Investigations have to be logical, systematic. They start with a legal purpose, for example, to identify the persons or persons responsible for an armed robbery. And then the record shows, or should show, how that purpose is translated into an action. So a study of the policy documents provides a way of determining if an investigation is fit for purpose. The process may also be used to secure the disclosure of information that may assist the defence or undermine the prosecution. Was the investigation competent? Was the investigation legal? Can the process be audited? Can the outcome be trusted? Thank you.
Anybody like to ask a first question? normal one?
For the CCRC to take on cases that have not been to the Court of Appeal.
Is it normal
How unusual is it for them to do
for
that?
the CCRC cases to take on cases that have not been to the Court of Appeal, presumably at the beginning when they were in the appeal?
It's fairly unusual, but it's not without precedent. The CCRC have got appellary exceptional circumstances what we can access to refer a case back to through the normal appeal process. I think one of the important uses of that, however, is when the only way of accessing material that may lead to the unsafety of the conviction becoming obvious is something that the CCRC can get their hands on and an applicant can't. There are other reasons as well why in the past they have used the exceptional circumstances, but never fall into the trap of thinking you absolutely have to go to the Court of Appeal first. It's normal to cases where the CCRC will indicate in any event.
Can you all hear that at the back? It's all right. Anybody who can't? Well, stupid question. But if you think you are hearing, give me a wave and I'll do something about it. Another question, please.
I just wanted to add to what Mark said there, because in my experience, the CCRC have actually been quite good about taking on cases which haven't been to an appeal, where the counsel in the case has said there are no grounds for appeal, and they won't recommend going to appeal. And the CCRC has been quite good at accepting that, oh well, they can't get to an appeal, we'll take on the case straight away.
Thank you.
What is the actual specific time limit for our caseworkers? Can we stay at the CCRC indefinitely, or is there a time limit? What's the turnover?
There's no time limit. There are, I think, the original 10 caseworkers who started on the 1st of May 1997. I think 4 of them are still there. There is a fairly regular turnover. I don't think it's entirely a bad thing. I think, especially among lawyers, especially among people who are a good long number of years of retirement, there is a chance of people becoming case argument in this day and so on. So I don't think it's a bad thing if people come as fairly experienced lawyers or investigators and leave them and into more investigation again in the future. I think I'll go through this now.
Anybody from the hall? A gentleman now.
Why is it that we have 2 different standards in the United Kingdom for appeal? The appeal court in England and Wales will only hear new evidence or a very, very narrow defined approach, whereas in Northern Ireland the appeal court there will, at their own discretion, look back at the original High Court trial and the evidence that was presented. That seems to me to be a totally unjust situation where we have one system in one part of the country and entirely different, but in my opinion a far better judicial system in another part.
We're getting far off Mark in a minute, put it down the table.
I think we need a politician on the bench to answer that.
You speak up.
I really think we need a politician on the bench to answer that. And just looking around for Lord Faulkner or Lord Smith, I can't see him. Sorry.
We don't know the answer to that. It's just the way our system is cocked up over the years. Question here.
Can you give us some advice about what type of things we can go to the CCRC if the defence barristers are basically not helping?
What kind of advice or what kind of information we can go to the CCRC if the defence barrister is not happy with you doing it? Is that right?
Can we do that alone, or do we have to do it?
Do we have to do it through the defence barrister, or can we do it individually? Thank you.
You don't have to go through. Yes, sorry. You don't have to go through a solicitor. You don't have to go through a solicitor or a barrister to go to the CCRC.
Should I just speak up? The way you like. With my live Lancashire accent, any of this stuff. You don't have to go through the CCRC to go through a lawyer, to go through to make an application to the CCRC. I accept the advice of trial counsel. There are other lawyers. One of the things that I'm rather upset the CCRC has done, and they haven't told me why they've done this, is that they've taken off their websites the rather helpful list of lawyers that have been there for years who are prepared to involve themselves on a pro bono or a free basis in cases involving the Commission. If you want, it's hard for me to answer what sort of things you could go to the CCRC without knowing the facts of your case. I think if you want a discussion over the break, I can have a chat with you, maybe point you either in a direction how to go about it yourself, or depending whereabouts in the country, whether I have some names of people that can help you.
Could I ask Mark myself, because I think it gets the picture, how many cases that go to the CCRC are actually referred, what percentage are referred on to the Court of Appeal, and how long? Because the first time I came to one of these meetings, there was, not like yourself, there was a spokesperson for the CCRC who said rather casually, oh, it probably takes about 2 years to get through the CCRC, and then you could wait for 2 years to get to the Court of Appeal. And that's what he actually said. And it was a deep, deep shock to me. So can you tell me what percentage actually get to the Court of Appeal, and how long the investigation by the CCR take?
The percentage of applications to the CCRC that end up as references on either conviction or sentence is about 4.5%. It's tiny as a percentage. And the advice, it's something that always thinks to screen some of the question, but the advice that whoever was at the last meeting we had from the Commission is about right. It can take years, and then it can take the Court of Appeal years in hearing the case. It really can take a long time. The waiting time at the minute for a case that the CCRC does not treat as a 5 working days or less.
So hand down there in the back.
Sorry, can I come back, Bruce?
Sure.
One thing I would say is this isn't really in defence of the CCRC, it's an observation. One thing that nobody ever said to me in 6.5 years as a caseworker was, Mark, you took exactly the right amount of time in dealing with that case. One or two things was often said to me. I don't think you've taken far too long, or, especially in a case when we refused to refer the case, you've not taken nearly long enough. Nobody ever said we've got the time element exactly right. And I don't know what that means, but I'm always interested.
No, excuse me, you had a lady down. I'm sorry, there is a lady about to speak. Please get up and ask your question, madam. Thank you.
When we put an application to the CCRC, we've been refused, and I've done the application for it, and it was absolutely brilliant. Now, all we wanted the caseworker to do was get off his backside and go and look at just part of what we wanted him to go and look at. And from that, we would have had a different story. You know, why won't we get off the backside and just do that?
I don't know the facts of your case, but I think it's very important that caseworkers at the CCRC are proactive, that they do get out of the office, that they do speak to people, and they do take an active look at evidence rather than waiting for things simply to arrive on their desk. Michael Mansfield once said in my presence that the most important thing for him in all the miscarriage cases he's ever been involved in is listening, and primarily listening to the person who's been convicted. And I think that's something that maybe ought to appear as a quotation above every case worker's desk in the town.
Gentleman in a pink shirt just in front. And I think this will be the last one before we break, because we're about to break.
I believe a few years ago the court raised the bar for a complaint against trial counsel from basically someone who's had an off day to having to prove that the counsel was flagrantly incompetent. Now technically, I understand that is a potential ground for appeal. Does Mark or any other criminal defence lawyer know, has an application ever succeeded to the Court of Appeal or by the CCRC on the ground that trial counsel was flagrantly incompetent?
Right, I could give you a couple of hours on the subject of legal incompetence. It's a hugely complex area of law. The concept of flagrant slightly from there. You're thinking of a case called Doherty and McGregor from about 9 years ago. I would say that this is open to argument, and if you have 6 lawyers on the panel, you probably hear 6 different opinions. I would say that the leading case of the Court of Appeal on that area of law is still the case of Clinton. What the Clinton judgment says is that the court should primarily focus on the ineptitude or alleged ineptitude of the lawyers involved, but on the impact of that upon the case and upon the safety of the conviction. You can have a tiny faux pas that can have a catastrophic effect on the case. You can have a pretty harrowing death, which can have a very minimal effect on the safety of the conviction. It's, I think, and certainly in the Clinton case, the Court of Appeal seemed to be saying to focus on the competency or incompetency of the lawyers is putting the cart before the horse. You want to look first at the impacts upon the defence case of what went wrong and assess the safety of the conviction accordingly. That said, the Court of Appeal does keep changing its mind, as you implied yourself, fairly often about that area of the law. It's always a case in which this space in the law reports.
Thank you very much, everybody. We're going to break now, and if you can be back in your seats within 20 minutes, we'll be able to start promptly at 1:45, so that new speakers. Thank you very much.
20 minutes.
Well, we have 3 more very interesting speakers, and the first one is Sekar, who's going to talk about forensic science.
For those of you who don't know me, I did a fair bit of work on a case called Cardiff Green. It's the Lynette White inquiry. That case recently made legal history as it's the first time in British history after a miscarriage of justice that the real killer was found and subsequently convicted. That happened on the 4th of July 2003. The original murder was in 1988. Now, I'm not going to bore you with all the details about that case, but if anybody wants to know, my book is available later, so you can ask me about that particular case. I would say that you also do need to know that because this person, Jeffrey Gafford, has pleaded guilty to Lynette's murder, there is absolutely no doubt whatsoever that the original defendants were and are completely innocent. That resulted in South Wales Police having to begin an investigation into what went wrong in the original investigation. To date, 13 witnesses and 19 former and still serving police officers have been arrested on offences ranging from suspicion of perjury to perverting the course of justice. A decision on who exactly is going to be charged is due by March of 2007, and it's possible that there will be further arrests, but I can't go into too much details about what has happened there. What I can tell you is how this case was eventually solved. DNA did play a very important part in this case, but the important thing to note is how did they know where to look. What they actually found was the original samples showed the murderer had cut himself and that there was blood which had come from a person with what was then considered a very rare combination of blood groups. These samples were stored properly, and further samples which had never been tested in the original inquiry were also subjected to testing. But what is really interesting is that a particular investigator was called in by the South Wales Police to look into this particular case. He put on a blindfold and ran through the flat. every place that he touched was then noted, and they scraped away the paint carefully, and underneath this paint was blood, which was later proven by DNA to have come from the real murderer. This is 15 years after the murder of Lynette White. That blood evidence was still there. So what you actually found from this is, one, it is actually possible to recreate the exit route of murderers from the flat. In this particular case, it was indoors, and it will probably be one of these situations where it affects indoor cases. The other thing that is really interesting to know is it turns out that paint is actually a really good preserver of DNA. And that is something most people wouldn't have thought. But they then found that having got the DNA of the real murderer, they then asked the original defendants to give samples of their DNA for elimination purposes. And it proved beyond any doubt that it wasn't their DNA. They then checked the National DNA database, and they found that there was no match whatsoever. However, it was noticed that one allele, an allele is another word for a band. You have 10 genes that they test at within the DNA chain, and you inherit one band or allele from each parent. One of those, of the 20, was very rare, and it eliminated 99% of the people on the National DNA database were eliminated by one allele alone. They then decided to apply this search at 8 alleles, and then 12, and then do it geographically. And what happened was it showed there was one profile in particular which was very, very interesting. It came from a male relative of the real murderer. That turned out to be a nephew of the real murderer. And so they now knew which family the murderer belonged to. And what was really surprising is that this person, Jeffrey Gaffor, the real murderer of Lynette White, did not have so much as a parking offence against him at the time of this murder. And for those of you who don't know, at the time, Valentine's Day 1988, this was the most brutal murder of its type in Welsh history. There were more than 50 stab wounds, including her throat being horribly slit. It was a nasty, horrible crime. This man, Gaffor, could have escaped all sanction for his crime if he had refused to give police a sample for DNA testing. However, he gave that sample, and he then tried to commit suicide, and his door was knocked in, his life was saved, and he was then taken to hospital and eventually pleaded guilty to the murder of Lynette White. Well, that immediately says that if he did it, and he did it on his own, there is absolutely no doubt that the original defendants were and are completely innocent. And they actually received a written apology from the Chief Constable of South Wales Police. Now you may think, well, what use is a written apology? And you would be right. It hasn't actually done the Cardiff Five much good at all. They are still, their lives are almost certainly never going to be the same again. One of them still has not been compensated yet, at all. Now this is, eventually there will be, probably in my opinion anyway, there is going to be a criminal case where responsibility for this particular miscarriage of justice is going to have to be taken by those who were actually responsible for what was, on any view, a complete travesty of justice. Now, this means, and the thing with this is, it's the one case where they can't say, well, we had the right people all along. This time they're going to have to come up with something imaginative to actually get out of this one. Or they're not going to be prosecuted again. Now, if they don't prosecute in a case like this, they never will. This is one where there is absolutely no doubt. But what I would suggest to you is that there is potential in DNA testing not just to prove guilt and not just to be indicative of proving guilt. It actually can prove innocence comprehensively. As while it proved Jeffrey Gaffor was guilty, it also unequivocally proved that the Cardiff Five were and are completely innocent. Now, the other point about this is DNA databasing now shows that even if you have the DNA of a male relative of the real killer, you can actually prove that people are not only innocent, but who is actually responsible. And this is where I'm probably going to get into trouble with all of you, because even though I strongly campaign over miscarriages of justice, am in favour of a fully independent national DNA database for everybody. But that is a database that must have safeguards. And the safeguards I'm talking about is that the police should have no involvement in this whatsoever. They should not be taking the samples. They should be nothing more than clients. And so should you. Your lawyers should have the right to instruct DNA experts to interrogate the DNA database. At the moment, it is in the hands of an allegedly independent organisation. It was in the hands of the Forensic Science Service. It has now been put into the hands of the very same people, but they have moved away from the Forensic Science Service to be part solely of the National DNA Database. The problem is, this is not a fully independent database. At the moment, the only people who can consult with this are the police. Well, I have one question to ask. Why? Why are the police alone allowed to use the National DNA Database? It potentially could prove the innocence of people in prison, and they should have as much right to have this tested, especially in old cases, or cases that predate the database. You should have the right to ask the custodians of the National DNA Database to periodically check it to see if there is any evidence indicative of somebody else's guilt. That, unfortunately, you don't have that right at the moment, and you won't have it until people start demanding that they have these rights. Talk to your lawyers, get them to write to the National DNA Database, ask them to check the database, and well, I would think they probably will refuse. And a refusal is no bad thing, because that means you have a decision that you can judicially review. And that is what needs to be done. Somebody needs to take up the cudgels of this and demand the right to check the National DNA Database over particular cases. Now, if anybody has any questions relating to that, feel free to ask afterwards. But now I'm going to move on to other issues. You need to look into the cases individually for various things. There is a case that I was involved with where I happened to notice that maggots had been taken by the pathologist, and I'll come back to this pathologist later, because he is without doubt one of the worst to ever practice in this country, and he's finally been caught up with it. But the important point of this particular case is that maggots were actually taken from the body, but this pathologist did not establish what the optimum temperatures were. He didn't establish the optimum conditions for the treatment of these maggots, and he almost certainly didn't inform the police what they should do with this. The answer is absolutely obvious. You consult a forensic entomologist, and you let that entomologist establish what evidence the maggots could give. In this case, that didn't happen. And not only did it not happen, what actually happened is that the police took the sample of live maggots, took them back to the police station, and promptly put them in the fridge where they died without being observed. Nearly 3 or 4 years later, after persistently demanding that they find out, of the lawyers to find out what has happened to these maggots, I was persistently told they're not going to exist anymore, there's no point in asking. I kept on at them. Eventually they asked, and the maggots were there all along. Nobody had bothered to ask. They were eventually examined, and they were in such a bad condition that the evidence that you could have got from these maggots was lost. So who carries the can for this? Who is the person who is responsible for the failure to adduce this evidence? According to our criminal justice system, you are responsible for the conduct of your own defence. not only do we expect teenagers to stand up to their lawyers, now we expect them to be up to date with the latest techniques in forensic science. So the one person who had no control over the treatment of this vital piece of evidence is the only person held responsible for it. Where is the justice in that? And this is in a case where the only way this person is guilty is if he is the stupidest person who has ever existed. And the reason I say that is his alibi is that he was with the person who alleged he committed the murder with him and the murder victim at nearby woods, rather than the one where this actually happened. Now, if anybody could come up with a worse alibi than that, I've yet to hear it. But that is what helped to convict this person. But not only do they say he's got to be that stupid, he then has to be smart enough to organise this murder. So you have this combination of the stupidest person who ever lived combined with the most intelligent and cunning person who ever lived in the same case. That is what they are trying to say has happened in this particular case. And that is because his own lawyers did not understand the potential of forensic science to test the credibility of the person who had accused him. And that brings us back to the person I mentioned earlier, the pathologist, Dr. Michael Heath. Have any of you got cases which involves Michael Heath? If you have, it may interest you to know that the Criminal Cases Review Commission, among other organisations, are currently investigating all cases put before them where Dr. Heath was involved. The person who is doing that investigation is David Jessel. When you are actually looking at this, now, I've just seen a reaction that isn't too impressed with David Jessel, right? But what you can do is, have you heard of a book called Trial and Error? That book was written by David Jessel. Have a look at the chapter called Murder in Toy Town. That is about Sheila Bowler, and in that particular chapter, he's rather critical of Dr. Heath. Now, there are other cases involving Dr. Heath which are actually proven, and these date back